Greetings to the respected advocates of Singh and Malik Associates. I would like to present the presentation on Hindu Marriage Act 1955. So talking about its beginning, the Hindu Marriage Act is based on the Hindu Code that was drafted by the Rao Committee, and its purpose is basically to regulate Hindu marriages and provide equal and reasonable rights to the parties involved, such as the option of restitution of conjugal rights, separation, and divorce by mutual consent, etc. It basically strives to bring about a uniformity in conditions related to Hindu marriages and to make them easier and less technical. Now, talking about the Act, it is applicable to entire India, including Jammu and Kashmir. Now, talking about different sections of the Act, Section 2 talks about the definition of a Hindu. It basically defines a Hindu as any person who is either a Veerashaiva or a Lingayat or follows the Brahmo, Pratna or Arya Samaj, someone who is a Buddhist, a Jain or Sikh, and someone who is not a Muslim, not a Christian, Parsi or Jew explicitly. Section 3 talks about certain definitions. For example, we have custom, and it is stated that a custom is anything that has been continuously and uniformly observed for a very long time, and it has obtained the force of law among Hindus. It is certain, not unreasonable, or opposed to public policy. It also defines Sapinda relations as those that extend as far as the third generation in the line of ascent maternally and fifth in the line of ascent paternally. It also talks about degrees of prohibited relationship. Basically, parties under a Hindu marriage, they can't get married within relationships which are prohibited unless the custom dictates. So there is flexibility. Then there is section 5 that talks about conditions for a Hindu marriage. So in order to validate a Hindu marriage, the following conditions they have to be fulfilled. First, bigamy cannot be practiced. That is, neither party should have a spouse living at the time of the marriage. Second, parties should be of sound mind, capable of giving consent and procreating children. Thirdly, the bridegroom should be of minimum 21 years of age, while the bride should be of minimum 18 years of age. However, if either of them are less than these minimum ages, then also the marriage would not be void. Fourthly, the party should not be within the degrees of prohibited relationship unless the custom permits, as already discussed. And fifthly, they should not be sapindas of each other. Section 7 of the Act talks about the ceremonies, that is the customary rites that the party have to include. For example, the saptapadi, that is taking of 7 steps before the sacred fire. There is also a provision of Section 7A in the Act which states that in the state of Tamil Nadu and in the UT of Pondicherry, there are certain other conditions that have to be fulfilled which validate a marriage. So basically for them, Saptapadi is not an essential condition to validate a marriage. Section 8 talks about registration, and it states that the state government will make rules providing that the parties they have to record the particulars in the Hindu marriage register. However, the validity of any Hindu marriage shall in no way be affected by the omission to make an entry. Then talking about restitution of conjugal rights, that is covered under Section 9 of the Hindu Marriage Act, it states that if either the husband or the wife has without any reasonable excuse withdrawn from the society of each other, then the aggrieved party may apply by petition to the district court for restitution of conjugal rights. Section 10 talks about judicial separation, which states that either party to a marriage may present a petition for a degree of judicial separation on the grounds similar to that of divorce, which we will now discuss. Also, when a decree of separation is granted, it will not be obligatory for the petitioner to cohabit with the respondent. Nullity of marriage and divorce. Section 11 talks about void marriage, and it states that if either of the parties had a spouse living at the time of the marriage, that is, he or she was practicing bigamy, or if he or she was of unsound mind, or was in a sapinda relation with the other, then the marriage would be void, it would be null. Section 12 talks about voidable marriage. It states that if a marriage has not been consummated due to the impotency of the respondent, or if the respondent is of unsound mind and get recurrent attacks of insanity, also if the consent of the petitioner or his or her guardian was obtained by force or fraud, then in that case the party, the appellant, has the option to get the marriage declared as void. Section 13 talks about divorce. Divorce is granted on the grounds of adultery, cruelty, desertion by the petitioner for a continuous period of minimum 2 years when the person is of incurably unsound mind, if he or she is suffering from communicable venereal disease, or if he or she has renounced the world by entering any religious order, or if he or she hasn't been hurt alive for minimum 7 years or more. Also, Section 13B talks about divorce on mutual consent, which is again a very flexible and modern provision that has been incorporated in the Act. Then there are additional grounds for divorce for women. For example, when the husband is guilty of bigamy, rape, sodomy, etc. Section 16 talks about legitimacy of children born of void and voidable marriages. Basically, the children, they would be legitimate. Then Section 17 talks about punishment for bigamy as per Section 494 and 495 of the IPC. Then, talking about jurisdiction and procedure, Section 19 talks about the court to which the petition will be presented. That is the district court within which the marriage was solemnized, within which the respondent at the time of the presentation of the petition resides, and the parties to the marriage last resided together. Savings. Section 29 talks about savings, and it states that a marriage that is solemnized before the commencement of this act, which is otherwise valid, shall not be deemed to be invalid by the reason only of the fact that the parties belong to the same gotra or belong to different religions, castes, or subdivisions of the same caste. Now, talking of a recent judgment under the ambit of the Hindu Marriage Act, recently the Rajasthan High Court ruled that a candidate who was expecting a divorce degree under Section 13, she wasn't able to seek any special preference, that is reservation, under the divorcee female category. Thank you. I hope the presentation was comprehensive and it was able to cover all the major points of the Act.